Seeking an adjournment.
Adjournment,
To the-
accommodation for
Yes, my lord.
accommodation for how much time?
As per your lordship, granted.
No, you submit. There's a section 5 application pending, learned counsel.
Yes, my lord.
So you are seeking accommodation for how many days?
Within 1 week.
The learned counsel representing the appellant, Okay. The instant appeal has been listed at the on the mentioning of the learned counsel representing the respondent, full stop, paragraph. The learned counsel representing the appellant is present, full stop. None is representing the respondent, full stop. The learned counsel representing the appellant seeks an accommodation for a week. Let the matter appear. Let the matter appear on 11th of March 2024 under the heading application. The learned counsel representing the appellant is requested to serve notice upon the learned counsel representing the respondent as regards to the next date.
Grateful, your lordship.
Next. আরেকবার second round call করবেন. None is representing either the appellant or the respondents. Let the matter appear on 4th of March under the same heading to be mentioned, 4th of March.
Lord, I appear on behalf of the appellant.
আচ্ছা ঠিক আছে যেন ছেলে করে রাখ ঠিক আছে can two. Yes.
Lord, the plaintiff, respondent are the appellants before my lord in a suit for declaration and permanent injunction. Lord, the suit was decreed by the learned trial court. Lord, the learned first appellate court reversed the decree against which, my lord, the second appeal has been preferred. Lord, in so far as and to the extent, Lord, facts would be relevant for adjudication of this can, Lord, I submit that the sum and substance of the claim of these plaintiff appellants was that their predecessor in interest got the title over the property by dint of an amalnama. Lord, amalnama. Lord, this document, Lord, is Lord more than about Lord 70-80 years old. Lord, the learned trial court, Lord, arrived at a finding that the plaintiffs have been able to prove their case, and hence, Lord, granted the decree. Lord, before the first appellate court, some interesting developments took place. Lord, one of the interesting development was that the respondents, Lord, without having filed any counterclaim before the learned trial judge, Lord, sought to amend their written statement.
In the first appellate court.
Yes. As well as, Lord, sought to, Lord, adduce further evidence. So, applications under Order 6, Rule 17 and Order 41, Rule 27 were filed.
Before the first appellate court.
Yes. ঠিক বলছি তো? এই application টা file করছিস? বলো না। না, না, এটা ঠিক আছে, একটা ঠিক আছে তো?
পিডিসেসররা কিন্তু আমলনামা নেয়নি।
না, না, ওইটা
আমলনামাটা পিডিসেসর নেয়নি।
হ্যাঁ, ওটা ঠিক আছে।
প্লেন্টিভ নাম্বার 1 পিডিসেসর।
Right, হ্যাঁ, হ্যাঁ। কিন্তু order
হ্যাঁ, হ্যাঁ, order 41, order 41.
yes, Lord, I stand corrected because that was Lord one confusion. The amalnama was Lord in favor of one of the appellants.
One of the plaintiffs, one of the appellant.
Yes.
First plaintiff.
Yes.
Plaintiff appellant number 1.
Yes. Now, my lord, both these applications were, my lord, oriented to improve the defense of the defendants, the appellants before the first appellate court, as also to raise a claim of cross title. They say that they are possessing the lands, they have title over the lands by dint of some other document.
They have title over the land.
Yes, by
Dint of other document.
other documents. Now that Order 41, Rule 27 application was taken up along with appeal. Order 6, Rule 17 application dismissed. Order 41, Rule 27 application dismissed. But the appeal was allowed in favor of the defendant appellants before the first appellate court. They are the respondents here. On the ground that the amalnama could not be properly proved in view of the fact the person who received the amalnama is alleged to have been born before the later than the amalnama was executed. That means that puts the probity of the amalnama under a cloud. So the document by dint of which the plaintiffs claim devolution of interest, that is under cloud. Trial court granted decree believing the probity of the document. First appellate court declined. In second appeal now, I'm sorry.
Whether this question was raised in the first, in the court of first instance, this question as regards to probity of the.
They raised it.
They raised it in the court of first instance,
Yes.
trial court.
No, in the first appellate court.
The first appellate court, this question was raised.
Yes.
Not before the trial court.
No.
It was actually, my lord, some of the some of the defendants, my lord, filed a written statement. They have thereafter, perhaps, my lord, so far I read from the order by the trial court, they did not appear. In appeal court again, my lord, they have.
Oh,
I was coming.
in spite of filing
Written statement,
nobody
appear.
contested.
there is some, my lord, communication gap, maybe with the advocates of.
Whatever might
what-
be, but the defendants did not contest after filing the written
Written
statement.
statement. That has been reflected from the
In
order.
the written statement,
Yes,
that-
that has been denied.
that has been denied.
Denied.
And a document which the plaintiffs claim is the pith and substance of their claim will definitely be denied in an omnibus manner in general or in a specific manner in the written statement, but that goes without saying. Now, the persons who raised the hue and
So as far as I can get, you are claiming the property through that Amolnama,
my lord,
and they are claiming the property
through some other
through
document.
some other document.
This document,
Itself.
this document,
Purchase and
this document was sought to be brought on record by filing an application under Order 41, Rule 27. That stood rejected. So the cross claim sought to be raised.
Honored Counsel, now the question is that, which is striking me, Order 6, Rule 17 not allowed at the initial stage in the first appellate court. How can that, on banking upon that Order 6, Rule 17,
And Order 41, Rule 27.
banking upon that, relying upon that Order 6, Rule 17, they had filed Order 41, Rule 27. If the Order 6, Rule 17
Goes.
what is the sanctity of value of the Order 41, Rule 27?
No,
Whatever might be.
Yes,
This is the question.
yes. So, my lord,
So it was taken up along with the appeal.
Yes.
Order 41.
In the judgment, it has been decided.
Decided.
so my lord, Order 41, Rule 27 was also rejected. But the first appellate court, my lord, believed their version with regard to the probity of the Amalnama, which is causing the devolution of interest in my favor. So the sum and substance of adjudication.
Again, learned counsel.
Yes. So the learned first appellate court declined the respondents before my lord an opportunity to raise a cross claim based on amended written statement and thereby declining them the opportunity to adduce further evidence by dismissing their Order 41, Rule 27. Now, Lord, the sum and substance of these proceedings from trial court until the first appellate court, in a nutshell, would be
Under relying upon which document the learned first appellate court reversed the judgment of the trial court?
I say, but the learned first appellate court did not believe in the probity of the document on which I say devolution of interest is occurring in favor of the plaintiff number one. Now, Lord, there are two aspects. One, the plaintiff's claim on the basis of the Amalnama, and the plaintiff has to prove its case. It cannot succeed on defense weaknesses.
No.
So the trial court decreed, but the first appellate court declined on the ground that the document which the plaintiffs rely to be causing the devolution is not believable. Now, on the other hand, so the title has to go to either of the warring parties. On the other hand, the attempt of the respondents herein to raise a claim based on an application under Order 6, Rule 17 was also not sustained. So the respondents also did not get any toehold either in the trial court or in the appeal court insofar as their claim being on record so far as the title over the property is concerned. the plaintiffs did get a toehold in the trial court because their claim was accepted by the trial court. So they got a toehold at least at one stage. Lord, kindly also consider that whatever these defendants, appellants before the first appellate court, were attempting to say by the amendment application was not done so by filing any counterclaim. My lord, I pray for a decree of declaration and permanent injunction in respect of this suit property. Now the defendants appear, file written statement. They decline that I have any right, title and interest over this property. But they do not file any counterclaim saying that not the plaintiff, but I have a right, title and interest over the property.
They simply denied your ownership.
There was no counterclaim. Even if my suit is dismissed, the defendants will not get a decree declaring their right, title and interest over the property. That is the law. Why I say this is that no counterclaim before the trial court and before the first appellate court, the attempt to raise a stand of a claim was also nipped in the bud at the threshold by dismissing the Order 6 Rule 70. In this backdrop, after having obtained the decree before the trial court and that decree having been taken away by the first appellate court, I came up before this honorable court against the judgment of reversal. And my case before the honorable division bench, as I have taken in my memorandum of appeal, was that a document which has been proved by extensive adduction of evidence has been disbelieved on the basis of documents which have not even been marked exhibits. And a document which is more than about 70, 80 years old, it carries a probity of a presumption of its genuineness. But the observations and findings of the first appellate court are perverse. On these arguments, the honorable division bench admitted my appeal, if I'm not wrong, on the 5th of December 2023. Substantial questions of law were framed. I was directed to send copies of Can 1 and Can 2 on the respondents. After having complied with that order, which initially my lord was not satisfied that I have carried out because I could not furnish proof of delivery, but then my lord's directions later on to that effect having been carried out, now the service in respect of the respondent number 4 is also complete. So all the principal respondents are served and are represented before my lord today. At this juncture, my lord, I am moving an application on being Can 2 of 2023, and the footage of this application stands on Order 41 Rule 5 of the Code of Civil Procedure. Lord, I am praying for, Lord, a stay of operation of the judgment and decree passed by the first appellate court. I am also praying for an order of injunction. Lord, I first will not press my prayer for stay. Now, Lord, the principles, Lord, guiding the powers and the discretion vested in an appellate court under Order 41, Rule 5 of CPC have been lucidly dealt with by the Honorable Supreme Court in the judgment of Atmaram Properties, which my lord have umpteen number of times must have had the occasion of coming across. Lord, paragraph 8 of the decision, if required, Lord, I shall cite the decision and place it. Lord, it says that mere filing of the appeal will not tantamount to a stay of the impugned judgment and decree. Paragraph 9 says, Lord, that the powers under Order 41, Rule 5 are discretionary in nature. Lord, equities need to be balanced. Today, if my lord would balance the equity, my lord would see as to what was the conclusion arrived at or the benefits derived by the respective parties or denied to the respective parties in the court of first instance. My lord would find that my version was accepted by the learned trial court and benefit was granted to me. If my lord then goes to the next stage, my lord, an ascertainment of facts would lead to that the benefits given to me were taken away by the first appellate court. My lord would further probe into the matter. My lord would find that the corresponding benefit was not reaped in favor of the respondents before my lord. So at no stage the respondents did get any benefit except for being successful in robbing of the benefit derived by me before the first appellate court. So there is no positive gain insofar as the right, title, and interest over the property in favor of the respondents. Standing at this juncture, I, my lord, pray before your lordships to put me in a situation where I was, had the impugned judgment and decree not been inflicted upon me, thereby robbing me of the benefit granted to me by the trial court. The basis of such a prayer is that the impugned order which did the inflictment of injury on me is under challenge before your lordships. It is under scrutiny before my lord, and a division bench of this honorable court has been pleased to prima facie adjudge the issue of merit of the appeal and has found that this raises a substantial questions of law. Lord, I stand a chance of being successful in the appeal. Is, my lord, the prima facie deduction that, my lord, we can arrive at on the basis of the admission of appeal. My lord, if today the impugned order is not stayed, then what happens? My lord, is to be understood to do the balancing of equities. My lord, if today the impugned order is not stayed, then the respondents will be at liberty to say that the plaintiff's suit has been dismissed. So today they cannot claim any right, title, interest, possession over the property because whatever was given to them by the learned trial court has been taken away by the first appellate court. If they are able to say that, then they may not be able by ipso facto to establish that if I do not have a claim, their claim is established, but they will have, my lord, all rights under the sun, maybe, to wrongfully interfere with my possession and at the same time depriving me of taking a stand before any authority, including the police authorities, to say that, look here, my right has been determined by a court of law in my favor. Because then what would be said is that the first appellate court has taken that benefit from you and you have filed an application for stay of that order and the Honorable High Court has not stayed the order. So what is not stayed? It holds the field, it operates in the field. Hence, my lord, I say, lest the respondents get that opportunity, my lord, the operation of the impugned order be stayed. because my lord is in scene of the matter. But the appeal deserves to be heard on its merit to test the sustainability of the appeal or court's order. And the sustainability of such an order has already been found to be a suspect by framing of substantial questions of law. Its operation need not be nullified today because the appeal is pending. It may be done so in finality. But at the same time, the vigor with which it is operating in the field has to be neutralized and kept in abeyance, subject to the outcome of this appeal. So, the operation needs to be stayed. This is my first branch of argument. Lord, my second branch of argument is that I have also prayed for an injunction restraining the respondents from interfering with my peaceful possession over the scheduled property. Now, when I make this prayer, I remind myself that I have submitted before my Lord that before the learned court of first instance, there was no counterclaim asserting right, title, and interest over the scheduled property qua the plaintiffs by the respondents. And the attempt to that effect was nipped in the bud, at the risk of repetition, I say, by the learned first appellate court. So, when the respective parties come before this honorable court, appear before my lord, the gamut of claims would be that the plaintiff is claiming right, title, and interest over the property, and the defendant respondents are denying it. There is no cross claim. Now, ideally, what should have been done? But I assume no advisory capacity when I say so, but I am saying it as a submission, that what could have been done is, even before my lord, a cross appeal could have been filed by the defendant respondents before my lord, saying that although my appeal has succeeded, but I am affected by the findings arrived at by the first appellate court in declining my claim insofar as the right, title, and interest attempted to be asserted by me by filing the Order 6 Rule 17 application is concerned. So, no counterclaim before the trial court. The attempt before the first appellate court was nipped in the bud, and there is no cross appeal before my lord. So, the bundle of facts forming the cause of action as they stand today is that my lord is looking at the claims of the appellant before my lord and a denial of such claims by the respondents, no cross claim by the respondents. I now need to show to your lordships that when I was claiming my right, title, and interest over the property, I was already in possession and I am in possession, and by an order of injunction, I am praying for protection of my possession till my lord determines the appeal. To that, I need to show that I am in possession. I was in possession. My lord, may now kindly take up the can 2. My lord, my lord kindly comes to page 4. My lord, page 4, I'll only place what is relevant at the moment. But kindly see paragraph 1 has Roman I. the appellants and or predecessor interests of some of the appellants lawfully became owners of considerable landed properties measuring about 44 decimals of comprise plot number 2134 corresponding to RS Kotian number so and so in Kusumgram police station so and so, now Purbo Bardhaman. And II is relevant. The appellants and predecessor interests of some of the appellants duly constructed brick building on the said property on due obtaining permission from the concerned Kusumgram Gram Panchayat and carried on inter alia the business of auto parts under the manner and style of SR Auto Parts thereat and therefrom and duly obtained required license from the appropriate authorities and more so kept their said business covered by insurances. So I am in actual physical possession by raising construction upon obtaining sanction from the local body and I am running business therefrom. Now, my lord, kindly permit me to refer to the relevant annexure. Lord, kindly come to Lord, page 1515. Lord, this is Lord, a certificate Lord, granted under Rule 58(2) of the Panchayat Rules in Form 11. This is Lord, an equivalent of what we Lord know in the municipal areas as trade license. My lord would kindly see the name. My lord would find Sheikh Samim Alam. Lord, he is the appellant number 3 before my lord. And my lord would see, my lord, village Kusumgram, right hand side powerhouse, then police station Monteshwar, post office Kusumgram, and just below that, dag number 2134. Which is, my lord, what is there in 1II. 1I, I'm sorry, 1I.
One item.
Huh?
One item. Oh, paragraph.
Now, Lord, kindly turn over the page 16. Lord, the name kindly sees Sheikh Jamiul Haq. Lord, he is the appellant number 2 before my lord. Lord, gets all the details which were there in the previous page. Page 15, my lord would find the trade registration number is 818. Lord, the third column. Fourth. Page 15. The name of district Purva Bardhaman, name of block Monteshwar, name of Gram Panchayat Kusumgram, trade registration number 818. This is in favor of appellant number 3, Sheikh Shamim Alam. And page 16, Lord, everything is same except for trade registration number is 954, which is in favor of the appellant number 2. Lord, the dag number is 2134. Lord, I intend to demonstrate that they are jointly in possession. I'm sorry.
Okay,
Lord, I intend to show that all these appellants are jointly in possession and are carrying on the business of auto parts, and each one of them has a separate trade license and have amicably partitioned the property between themselves, making shop rooms and running their business therefrom. They are in actual physical possession. And these are, my lord, kindly sees the date issue date 21st January 2023. Recent document. My lord, kindly now comes to the next page, page 17. Lord, kindly sees trade license fee in serial number 4. for business of SR Auto Parts. And then kindly see, my lord, serial, the top amount 500 received from Sheikh Abdul Rafiq. He is the appellant number 1. My lord, kindly comes to the next page, page 18. My lord, this is a license under section 116 of the West Bengal Panchayat Act for carrying on trade or business for the year, kindly sees 1997-98. I am showing documents of varied periods. First, I showed the recent ones to show that I am in possession. Now I show 97-98. And this is not in favor of Sheikh Abdul Rafiq, the appellant number 1. My lord, kindly turns over the page. My lord would find the valid for 2006-2007. My lord has very kindly got it, my lord. 2000, page 19. 2005, 2006, 2006, 2007. Renewal. Then, my lord, kindly sees hereby grant to Sheikh Abdul Rafiq, appellant number 1. Page 19. And then, my lord, kindly sees the Bengal Panchayat Act 1973 for the use of place covered by CS plot number 2134. This is, my lord, the date of issue is 21st March 2007. Next page, my lord, is a receipt issued by the Jela Panchayat Samiti of 1000 towards trade license renewal for the year so and so. Page 21 is, my lord, identical document. Kindly come to page 22. This is, my lord, issued by the Directorate of Cottage and Small Scale Industries, 15th May 1996. Your application is accepted for provisional registration as an SSI unit for manufacturing of items activities as stated in application form. Page 23, my lord, is an receipt issued by the Kusumgram Gram Panchayat in the year 1996, precisely on 20th May 1996. Now, kindly come to, my lord, page 24. But kindly see, my lord, the top head. কুসুমগ্রাম গ্রাম পঞ্চায়েতে গ্রামের মধ্যে ইমারত বা কাঠামো নির্মাণের অনুমতির জন্য আবেদন so and so. I make an application. Kindly see, my lord, the DAG number. My lord has found, my lord, the DAG number
134. Yes.
This is, my lord, 1996. My lord, then, my lord, kindly come to page 25. My lord, this is, my lord, to the Kusumgram Gram Panchayat that is issuing this certificate. On the left hand side, immediately after the narrative of 5 lines ends, প্রাপ্তির হিসেব খাতা গৃহ নির্মাণের, my lord has found that, my lord. Kindly turn over the page. This is গৃহের কোনো অংশ নির্মাণের বা গৃহের কোনো অংশ বর্ধনের অনুমতি প্রাপ্তির জন্য আবেদনপত্র। Lord, kindly see page 27, next page. Sheikh Abdul Rafiq, right side, right hand side, in the middle. My lord has got it, my lord. He's the appellant number 1 before my lord. My lord, kindly come to page 30, 30. My lord, a shop is insured with national insurance, page 30. So not that I have just obtained a license and the shop is lying closed or like that. Page 31. The insurance has been obtained by Sheikh Abdul Rafiq, the appellant number 1 before my lord. On the left hand side top, my lord would find that proposal come policy schedule for shopkeeper insurance, Sheikh Abdul Rafiq, care of SR Auto Parts. Lord, on the basis of, my lord, these pleadings and, my lord, the annexures, my lord, in support thereof, I say that, my lord, these documents would go to show prima facie that I have been and I am in possession of the scheduled property. Prima facie. And now I take, my lord, to my prayer, my lord, for injunction. Lord, kindly come to page 9, paragraph 5. I'm sorry, page 8, paragraph 2. I'm so sorry. The appellant's petitioners say that presently they are in absolute and exclusive possession of the suit land. But although the respondents using the impugned judgment and decree dated 17/11/2022, this is the first appellate court's decree, as a lever, are constantly disturbing the appellant's peaceful possession over their lawfully owned, occupied, and possessed lands, and or are also seriously disturbing the appellant's ingress in and egress out from the suit land. My specific allegation. So their stand is that whatever you were claiming yesterday on the basis of the decree of the trial court is no more there. Our status is that our respective claims are under the open sky. You enjoy no greater benefit than what I enjoy. That is their stand. That paragraph 3, that more so the respondents have no sort of right, title, or interest in the suit property despite the force of impugned judgment of the learned appeal court below. The sum and substance of this is that not that because the decree granted by the trial court has been reversed by the first appellate court, any benefit has accrued in their favor. Paragraph 3 is paragraph 4. The respondent herein always boasting of their police, political and anti-social connections and flaunting muscle power, take extrajudicial measures to take forcible possession of a part of the appellant's land and to create illegal restriction upon the appellant's entry into and exit from his property as well as a business area. That is what they intend to do. And paragraph 5, the appellant's petitioners have good grounds of appeal and have the fairest chance to succeed in the appeal in the premises if the respondents, armed with the force of impugned judgment and in association with their antisocial associates, succeed in disturbing the appellant petitioner's peaceful possession over the sued property. The appellant petitioner shall suffer irreparable loss and injury, and their preferring this appeal shall totally be infructuous. Why? Because I showed to your lordships that I have made construction upon obtaining permission from the panchayat. I have obtained trade license. I am running business from there. My livelihood would be at stake. Then, Lord, paragraph 6, I have prayed for staying the operation. And paragraph 7, I say, the petitioners are also entitled in law to pray for and as such pray for an order of injunction restraining the respondents, their men and associates from disturbing their peaceful possession over their said land and from creating illegal restriction upon appellants' entry into and exit from their said property as well as business area. This is the injunction, Lord, I am praying. And Lord, one submission which is a sine qua non when an prayer for injunction is made is balance of convenience and convenience. Pitted in a situation where neither the respondents have claimed any right, title and interest, nor has such claim attempted to be raised before the first appellate court been succeeded, nor a cross appeal having been filed before your lordships today. And having regard to the fact that I have been able prima facie to prove my possession over the property, the balance of convenience and inconvenience lies in my favor because my right to livelihood is at stake. If the respondents are not injuncted from illegally interfering with my possession in respect of the property in the interregnum and during the pendency of the appeal, Lord, I shall be severely prejudiced. I repose fullest confidence in this honorable court that the appeal would be disposed of within a very short time. But the bitter experience, my lord, of over the years have, my lord, taught us that it takes some time, and it is always better, my lord, to take a practical approach and invite the honorable court to a pragmatic view of the entire matter, that despite this honorable court wanting that this appeal should be disposed of within a month, it will take time for the lower court records to come, to be notified to the advocate for the appellant, paper books to be prepared, service to be complete, then matter to be listed, heard and disposed of. It will take time. During the interregnum, my right to livelihood and my possession in turn be protected before your lordships. Those are my respectful submissions before your lordships.
Anything more?
I am grateful to my lord.
So far, my lord, I understand from the submission of Mr. Chaturvedi that we have not filed any counterclaim. And on that basis, he is trying to establish his case. My first submission in that respect would be plaintiff has to prove his own case, his settled proposition, not upon the weakness of the defendants. Even I do not file any claim, plaintiff has to establish his own case. How the plaintiff has been established his own case before the trial court? In the only written statement filed by the to my lord defendants. Thereafter, they did not, for any reasons, they did not appear. And on that basis, whatever the submissions were there, they got the decree. Before that, my lord, I would submit the basis of the claim, the plaint, our written statement, whatever we have filed, that perhaps is not available with mine. What was the plaint case? And what was our defense as regards up to the written statement? That is not available with the mine. I say, my lord, entire land is referring plot numbers, that referred plot number. Total plot is 45 decimal. My lord will get from the orders, judgment degrees of the both the court belows, my lord.
It has been admitted 45 decimal in the
45.
to the application also.
They, my lord, rely on an Hon'ble. By amendment, they have taken this point before the trial court. Since we are not there, my lord, it has been allowed and accepted. And in the Hon'ble, they are claiming 3 decimal. Initially, my lord, their stand before the
Lord Counsel, this point be cleared. Whether they are claiming 45 decimal,
no,
3 decimal out of 45 decimal.
because they cannot claim 45. I'm coming, my lord. 3 decimal. And we are claiming 2 decimal by our purchase deed. Not claiming, we said it is our ownership. Because as per his version, we have not filed any. Yes. Because we are in possession. That I will come. What was their case? Their case was because plaint is not available to my lord. From the order, I find, my lord, initially, my lord, they say out of 45, 26 decimals acquired by PWD department. Page 11 of the trial court order. In our page 11 of the trial court's order. That is, my lord, connected with the stay application. Stay application. The stay application. Stay application.
Page 11.
Page 11, bottom.
Yes. Now it is to be seen.
How far the plaintiffs have succeeded to prove their case beyond any reasonable doubt. Plaintiffs at the time of filing of the suit, while presenting their claim, states that out of 45 decimals of suit land, 26 decimals have been acquired by the PWD and 17 decimals have been acquired by the WBACD.
Lord, my lord, may kindly excuse me, my lord. Can I have some water and come back?
This is one. By my lord, may I repeat?
45 decimals.
Out of 45, 26 by PWD and 17 by WBACTCL.
So
That comes to
remaining 2 decimals.
43. Yes, 2 decimal. This is their original plaint case. And we purchased, my lord,
So,
this
and he obtained the settlement for 3 decimals.
3 decimals. As he says, my lord, I will Later I will come that on that points also. How he is title, he is deriving the title. And to fill up this lacuna, my lord, in our absence, my lord, court has nothing but to accept their submission in page 12. My lord, may I read from the page 11, bottom. In the appeal case numbers such and such against the injunction petition, this fact has been clearly reflected in the order portion in page 3 at 11th line, that if the total area of the plot number such and such is 45 shotaks, out of which PWD and WBACDCL ACB 26 and 27 shotaks respectively, but remainder is 2 shotaks. Only it cannot be 3 shotaks. Under such circumstances, the plaintiff's respondents must explain where did then the remaining 1 shatak goes. Schedule 3 shatak. But later on, plaintiffs by way of amendment petition managed to change the proportion and said amendment was allowed by order number such and such. And thereafter, it was amended in the place of 17 decimal, 14 decimal. 17 has been changed to 14 and was inserted, and in place of 25, it was 26 was inserted. And thus remained 5 decimals in the property. If 5 decimal remains, they are claiming 3 decimals, we are claiming 2 decimals. There is no difficulty. There is no difficulty as per calculation regarding the share in the property. Position may vary. But my lord, may I, my lord, read the thereafter, my lord. Plaintiff as PW1 narrated the entire plaint case through examination in chief and has exhibited certified copy of Khotiar number such and such, name in the name of Amol such and tax receipt, etc. in the name of plaintiff recorded in the such and such. Thereafter, my lord, will find the exhibit last line of that paragraph. They exhibited exhibit A.
Which portion?
Last portion, para 12, first paragraph, last portion.
Exhibit A.
Yes. What was the exhibit A? That was the LAK's notification of the WBACDCL, which earlier they say 17 decimal. By amendment said 14 decimal. And that was exhibited before the court. And I presume, my lord, while deciding this trial, the honorable, the learned trial court, going through the record, passed the judgment and decree in their favor in our absence. Now, what is exhibit A? May I, my lord, since record is not available with my lord,
আরে ভাই এক্সিবিট দেখিয়ে কি অ্যাপিলটা শুনানি করবে এখন?
This is the list of exhibit. May hands up the notification which they have exhibited. Kindly excuse, I have marked it. Plot number and portion.
Let him file an affidavit in that case if he is relying on document which is
Because
not.
that I want to file. That I want to file because today before my lord, plaintiff is not there, written statement is not there, exhibits are not there. Without any basis, he is paying for an interim order. My lord, kindly have a look once for satisfaction.
Learned counsel, to
Huh?
that effect, to file an affidavit in opposition to the
Yes,
application.
Yes, let him file.
only for once, my lord, satisfaction.
This is the schedule of the plaint.
No, this is the exhibit A. That is notification, public record,
Of the LA case.
LA
What was
case.
the LA case?
LA case of PW, that is electric department, WSCDCL. My lord, got the number?
17 decimal.
Yes. To cover up his case, in our absence in the amendment, they reduce the area 14 decimal from 17. It is their exhibit. So, my lord,
It has been exhibited before the trial court.
yes, that has been recorded in the trial court. Exhibit A.
Learned counsels,
My lord.
the turn which has taken place, whatever might be. I think an affidavit in opposition.
Oh, very much.
Is
I
required
don't
to
stand in
file.
the way. I don't stand in the way. But only one thing, Lord, the sum and substance of argument until now, it revolves around an amendment which has been already allowed and permitted to remain unchallenged until now. All amendments, my lord knows, they relate back to the initial date of filing of the plaint. I put that question to myself in such circumstances, was it wise on the part of the learned first appellate court to look into my unamended pleadings? Was it permissible? Because my unamended pleadings were already wiped off from the records because the amendment was not challenged. So what remained on record was an amended plaint, and my lord knows, again at the risk of repetition, I say all amendments relate back to the date of filing of the suit. What I initially said and why and how I altered it, and the learned trial court was wrong in allowing the amendment, and I could secure that amendment being allowed because they did not participate in the proceedings. We are today at a stage of appeal having been admitted by the Honorable Division Bench. Possession, who is in possession? That is a sum and substance. Today, exhibits being shown to your lordships. Kindly see what has he said in his plaint, unamended. Then kindly see this amendment. Is this amendment correct? The learned first appellate court is saying.
Subject to, I did not say. I did not say amendment is correct or not. I did not utter any word to that respect. I said only the schedule of the plaint. I beg to differ. What I have not said, please kindly do not put the word in my mouth.
Schedule of the plaint is a part of the plaint.
Counsel,
An amendment.
Mr. Betal was
Yes, ma'am.
Mr. Betal was showing the document
Exhibit.
which has been exhibited on behalf of the plaintiffs.
For what purpose? I put this question to myself.
Hmm.
For the purpose of indicating lacuna in my pleadings, which will be tested when the appeal would be heard. Today, my lord is not hearing the appeal, my lord, we all know. Today, my lord is not hearing the appeal, we all know. The appeal will be heard,
Counsel,
my lord.
if, for the sake of discussion, if at all status quo is passed, if at all, after hearing both sides and considering the affidavit in opposition and reply, if any, then in that, prior to coming to the conclusion as regards to status quo, this court will have to come to the conclusion that this portion is being possessed by the appellants and the remaining portion is not being possessed. And as regards to the nature and character also, the court will have to assess that this is being used for this purpose. After all, after that consideration of the possession extent of possession and the nature and character, status quo can be passed after what has been decided by the Honorable Apex Court. Mere status quo cannot be passed.
There has to be an observation,
Yes, there has to be a detailed observation as regards to
a prima facie opinion
prima facie opinion
as regards who is in possession,
in possession
and then status quo.
and status quo, and as regards to nature and character also.
Yes. And today I have placed documents of varied periods indicating that I do not claim possession on simpliciter basis of statements on oath, but documents by local bodies and government bodies which indicate my possession in respect of the 3 decimal lands scheduled property. The prima facie opinion has to be arrived at based on documents, not on the words of mouth. I again say, at the risk of repetition, that title follows possession. Where is the respondent's counter claim or cross objection raising a cross title to face my claim of title? He is simpliciter raising an issue with regard to my possession at a stage when the appeal is admitted.
Mr. Chaturvedi,
It is slightly,
Mr.
not it,
Chaturvedi,
I'm sorry,
I have a division bench at
My lord.
1 p.m.
my lord.
and affidavit in opposition is required to be filed. When it can be, how much time do you take?
2
Will you
weeks.
take?
2 weeks. At
No,
least
not council. Not 2 weeks. 2 weeks, affidavit in opposition to can 2.
So I have to bring those documents on affidavit because they have not produced the plaint.
Council,
At least 2 weeks.
If I have 50,
all-
if I have 50 applications for stay in my chamber, maybe in 1 or 2 applications, by mistake, I will find that the application copy of a plaint is annexed. It is never required to be shown to the court a copy of the plaint when I am praying for a stay of operation of an order passed by the court below, because I am entitled to it in invocation of the discretion under Order 41, Rule 5.
council, it be filed within 12th of
আজকে কত তারিখ? 12 onwards.
My lord, may I propose?
Well,
Kindly give him the remaining 2 days also. My lord is giving him 11 days.
I'm giving him
11 days. Lord, kindly
2 weekends.
let
2
him
weekends.
Yes,
let him go satisfied from the court that my lord has conceded to his prayer of 2 weeks.
না
11 I'm supporting you.
এটা বলা দরকার।
Let him go
জজ
satisfied.
যেটা ঠিক করছে সেটাই করুন।
Let it be earlier, not 2 weeks is not required for
Yes.
filing affidavit in opposition to this one.
2 দিনের জন্য অসন্তুষ্ট থাকবে কেন?
12 তারিখ থাক।
And copy to be furnished.
Yes.
Copy to be furnished prior to that filing.
তাহলে তো আবার সব করুন।
বলো, আমি তো তোমার হয়ে বলছি না, তুমি বললে না লাগে না।
To that, then it comes down to 7 days. It would be difficult.
Let the council reply if any.
Because why I say, my lord, all along in this suit, my lord,
7 days.
So let the affidavit in opposition be filed
by 12.
by
But-
12th after serving copy upon
Yes.
the other side,
Yes.
and reply if any be filed
By 19th.
by 19th.
Yes.
The matter will be taken up on 20th.
20th.
In the meantime, kindly do not leave me high and dry under the sun and to the mercy of the respondent.
My lord, for years together,
I am-
my lord, during the suit, during the appeal, there was no. Yes.
Learned
Yes.
councils.
Yes, my lord.
Now, let this court direct both the sides to maintain what is prevailing at this point of time.
It is oral or my lord?
No, it is oral.
Oh, yes, absolutely.
be-
I have no difficulty.
That should be maintained.
Yes.
Otherwise,
Yes,
otherwise,
my lord,
there is
my
no
lord,
any
my
no
lord,
other
if
alternative.
if I take it as out of court, আমার মক্কেল তখন এখন যায় না।
That should be
They are not even going to the, because client's son is working in Salt Lake. They stays here. They did not even go there. It is one cycle shop was there, that was lock and key. This is the factual aspect as of now.
My lord, one eventuality my lord would kindly foresee before my lord is passing an order. My lord, if there is a change in determination, we shall never have an opportunity of
No,
coming
that's
back
counsel.
to your lordships.
Counsel, I cannot assure you, but that won't be in the
And-
meantime.
No, I say in the event of an eventuality, we shall not have an opportunity even to go to my lord's chamber and say that when my lord was taking up this matter and had jurisdiction, oral assurance was given by Mr. Betal. Today he is merely sipping a cup of
No.
coffee and his client has dispossessed me.
It is a learned counsel. The goodwill of the learned counsel is at stake. Learned
My lord,
counsel.
as per his submission, no general diary, nothing is there in the.
My submissions on oath.
Avertment.
Lord, then kindly stay, at least stay the operation of the impugned order. Stay the operation of the impugned order. That is the minimum. That is the minimum I deserve.
2023,
It would be final decide.
hearing for the learned counsel. Appellants at length.
আপনি আর কিন্তু আরে দাদা আপনি রেকর্ডটা নিয়ে আসুন, পেলা খরচা ফরচা গুলো নিয়ে আসুন, ওগুলো judgment গুলো নিয়ে আসুন।
Learned counsel
Recent লিখতে হবে।
representing the
ঘুমান, আমি কিন্তু আর রাখতে পারবো না, দাদা সব নিয়ে চলে যাবে।
it is evolved that affidavit in opposition is required to be filed. It has evolved that affidavit in opposition is required to be filed. Stop. It should be circumstance. Let the affidavit in opposition be filed. Let an affidavit in opposition be filed
এটা রাখো, কেউ ফেলে
12th of March 2024 after serving copy upon the other side, and affidavit in reply, if any, be filed within 19 after serving copy upon the other side. The matter will be taken up on 20th March. Learned counsels.
Yes, my lord.
Stay of operation is, it's an innocuous order. Stay of operation.
That does not matter.
The extent this court has heard the matter, I
know.
think
It would be
60% of the matter has been heard.
Hmm.
Only 40% is remaining to be heard to dispose of.
If my lord desires, my lord, it can be joint prayer, my lord, it can be part heard, marked as part heard. I have no difficulty.
At this stage, how can it be marked part heard?
Lord, because both parties are appearing, my lord has heard 60%. Lord, stay of operation. That is not an innocuous. It does not affect anyone.
Does not permit even order 41 rule 5.